Welcome to Fairly Competing, the show providing in-depth analysis of trade secret law and the law of non-competes and other restrictive covenants. Whether you're a business owner, CEO, in-house counsel, HR executive, or other employee, or a new lawyer or advanced practitioner, join us for a discussion on the latest trends and hot topics, evolving federal and state laws, key developments, and other emerging issues in trade secrets, non-competes, and employee mobility in today's knowledge economy. And now, here are your co-hosts, John Marsh, Ben Fink, and Russell Beck.
Thank you, Erica. Here in Boston, Russell Beck.
Here in Atlanta, Ben Fink.
And here in Columbus, John Marsh.
Well, welcome everybody to our next episode of Fairly Competing. We are looking at the year in review for 2024. What happened in the past year and what are our predictions for what we think is going to happen next year? Yeah, well, this year, 2025. So with that, who would like to kick it off?
Boy, the silence is deafening. I don't know that I don't think in any conversation we've ever had, any of us have hesitated to speak. So I'm kind of flummoxed. Hey, you know what, Russell? This may be a little out of order, but to me, the biggest issue was probably what happened with the FTC. That had everybody's attention throughout the country. I mean, you had editorials in the Wall Street Journal, the New York Times, basically any media. Yeah.
Don't forget our blogs. Yeah.
What's that?
Don't forget our blogs. We had a lot of
course. Yeah. Well, last but not least. But why don't we start with that? Because I think there have been some interesting developments as of late. And would you mind taking us through that at a high level?
Yeah, you could probably relate it back to this time last year.
Yeah. No, we could definitely do that. It does have some nice symmetry. So a lot actually happened with the FTC. And I'm going to give everybody just a little bit of context so we can bring people back into thinking about this, which a lot of people, other than us, I suspect, have really stopped doing. So, and perhaps when I say us, maybe it's just me. So
I think that's right.
So it all goes back to 2018 when the FTC started looking into non-competes. And that's the first time that you have the federal government looking at regulating non-competes, other than through Congress, which started doing that in 2015. But this actually had a chance of moving forward. And as we know, it did. So in 2020, the FTC held a full day in-person workshop and took a lot of information in, and then held a subsequent workshop in December of 2021. And in the interim, President Biden had his pre-inauguration platform, which included some sort of regulation of non-competes. And then you had Lina Khan sworn in as the chair of the FTC. And you also had President Biden issue his executive order in the summer of 2021. So that all happened in between those two workshops. And then you move forward, and on January 4th, 2023, which I can't believe is now 2 years ago, the FTC on the 4th issued a few enforcement actions or notices of enforcement action. And then literally the next day issued a notice of proposed rulemaking that would ban all non-competes. And in support of it, they cited a whole bunch of research, a lot of it from Evan Starr and some others. But one of the things they said is, and we're experts in this area, see our enforcement actions from yesterday. And those enforcement actions was like the first time that the FTC actually did anything related to non-competes, but they claimed that it was this, historic, strong depth of knowledge. So the notice of proposed rulemaking was basically a ban of non-competes. We can get into the nuances of it. I don't think we need to for today's purposes, but fast forward, they received a lot of comments. They received certainly a lot of favorable comments, mostly, I think, from individuals, oddly from unions, which I've never really understood. They received some from some of the attorneys general around the country, which I thought was really interesting, given that the attorneys general are charged with enforcing the laws in their states, and this would basically undermine the laws in most of their states. They received letters from us, and they received letters from a whole bunch of other interests, including the U.S. Chamber of Commerce and some others. And the U.S. Chamber of Commerce, of course, took the position that they would challenge any rule, period, because the FTC doesn't have authority to do it. Anyway, fast forward to April of this past year, April 23rd, and the FTC issues the final rule, so-called. And that rule was very similar with a few changes, but it was very similar to the ban that they had proposed back in January of 2023. So in April of 2024, they have this new rule that comes out, and the new rule basically says full ban of non-competes for employees. There are a few very limited exceptions. Any non-compete that you had with any employee other than a so-called senior executive would be wiped out. So whatever agreement you may have had to date, that agreement is no longer effective as of the effective date of the rule, which would have been September 4. And so they did have a carve out, though, for if you were a so-called senior executive, then your non-compete, if it was signed prior to the effective date, could be enforced after the effective date. If it was signed after the effective date, it violated the rule. So senior executives, which was a very limited group, again, I won't get into the details because it doesn't really matter at this point, but that was one of the few exceptions. Another exception was if there had already been a violation of the non-compete, you could enforce that after the rule went into effect. And they allowed for non-competes in the context of a sale of business, which is fairly routine around the country. Even California, Oklahoma, North Dakota, Minnesota allow for that. So again, fast forward, and this rule comes out, and the day that it came out, it got challenged. I think it might have been within, I mean, it was certainly within hours. I don't know, it may have been within the hour that a company called Ryan LLC brought an action in Texas court in the Northern District of Texas challenging the rule. They did that in some people's views, in a way that undercut the U.S. Chamber of Commerce, because the U.S. Chamber of Commerce had been saying all along, we are going to sue, we are going to sue, we're going to sue, and they didn't get their act together to do it until the next day. And then ultimately, what wound up happening is that the Chamber of Commerce case wound up going away, and the Chamber of Commerce joined into the Northern District case with Ryan. So the Chamber had filed in the Eastern District of Texas. In the meantime, the next day, so that was April 23 was the date of the rule. April 23, later that day, was the day Ryan sues. April 24, the Chamber sues. And April 25, ATS Tree Services, a 12-person tree cutting company in the Eastern District of Pennsylvania, filed a lawsuit challenging the rule. Nobody could figure out at the time why ATS filed that lawsuit, nor could anybody figure out why, of all places, they would file in the Eastern District of Pennsylvania. In any event, fast forward very quickly to what happened with all of these things. Well, the ATS case was the first to go away. They lost their injunction. The court said that the rule was valid, and the ATS case, and ATS ultimately dismissed the case. In the meantime, the first case to issue a ruling was actually the Ryan case. And in the Ryan case, the court said the rule is invalid and the FTC had no authority to issue it. But the initial ruling that came out of the Ryan case was very limited. It only applied to the parties. So at that point, there was a lot of question around, all right, well, if it only applies to the parties, are the members of the U.S. Chamber of Commerce considered to be the parties? Are they not? You had all these questions. It created so much uncertainty. And ultimately, before the effective date, was it August something? August 20th. It's August 20th, which was actually a few days early. The Ryan court said the rule is invalid and it applies to everybody. So you had that decision in Ryan. And then in the meantime, you had an 11th Circuit decision, Florida, Middle District of Florida decision, a case that was filed by a company called the Properties of the Villages. They brought a lawsuit in the Middle District of Florida. That was back in June. So that's, all the stuff is already happening in these other courts. And then suddenly this company files suit in June in Florida. They get a preliminary injunction, but applied only to them. And the FTC appealed that. So that appeal actually started. It's an appeal of the preliminary injunction. And that appeal started in the 11th Circuit before we wound up having any appellate process going on in the Fifth Circuit in the Ryan case. So ultimately, the FTC in the Ryan case appealed the Ryan decision, and that case is up on appeal. So now you've got two cases on appeal, one in the 11th Circuit, which is appealing just a preliminary injunction, and one in the Fifth Circuit that's appealing a final permanent injunction summary judgment in Ryan's favor. That appeal in the Fifth Circuit is in the process of being briefed. The FTC literally yesterday, so that was January 2nd, we're recording this on January 3rd, filed its appellate brief, and that case will move forward, maybe. Talk about that in a second. In the meantime, the 11th Circuit briefing is ongoing. The FTC filed its brief there on November 4th, and the properties of the villages will be filing their brief on January 15. But again, that case really would be the tail wagging the dog. That case was fairly limited. The case in Texas is the one that says nationwide injunction going up to the Fifth Circuit. There's been some activity at the Fifth Circuit separately, unrelated to this, in which the Fifth Circuit vacated a broad injunction from a lower court, much like the broad injunction that the Ryan court issued, only to a few days, which gave everybody a little bit of concern. Because if the Fifth Circuit is looking at the lower court's, broad-based nationwide injunction and saying, hey, that's kind of too broad, you shouldn't be doing that, and striking it down, everybody started to worry, okay, well, what's going to happen with the Fifth Circuit when the Ryan order comes in? And thankfully, I don't remember how many days later, the Fifth Circuit, another panel of the Fifth Circuit, basically just reversed that. So there is still a full-on nationwide injunction that's been endorsed by the Fifth Circuit. And we fully expect, I fully expect that that will happen again in the context of the appeal of the Ryan Court's summary judgment and permanent injunction. The only thing that I see potentially changing that is there's a changing of the guards. With the new administration comes a new chair of the FTC. Chair Khan is out, and Chair Ferguson is in, or will be in. Ferguson was appointed, he's a Republican, he was appointed to the FTC, I think it was in 2024. And I know it was before the rule came out because he was very opposed to the rule when it first came out. So the idea of him continuing with the appeal, I think, is very unlikely. But I also think that there's a process at the FTC for having commissioners appointed. And I think absent confirmation of the commissioner that Trump is appointing to fill what would be a vacant role there, I think we're stuck with two Democrats, one Republican, plus Ferguson as the chair, who's a Republican. The two Republicans voted against the rule. The two Democrats voted in favor of the rule. So once the new Republican is confirmed by the Senate, presumably, they will line up with the others, with the other Republicans, and then we'll see whether the FTC will pull the appeals. So that's really it. That's the status. I think it's going to be very interesting to see how that all plays out.
Was it Ferguson that had the allusion to the Big Lebowski quote in his dissent?
What was that?
Wasn't it he who said something, cited one of the legal doctrines as having been roundly rejected?
He may have. I don't recall his, but I do recall the 11th Circuit, when you talk about these quotes that come out of these cases.
Right.
Actually, I take it back.
It was the Middle District of Florida, right?
Middle District of Florida.
Yeah.
That's right. So the Middle District of Florida had a great line in their decision. They borrowed from Justice Barrett's decision in Biden versus Nebraska, 2023.
I got it right here, so I can read it.
I got it. No, please go ahead. I was going to read it, but you got it. Go ahead.
No, I don't want to steal your thunder.
No, steal my thunder, John. Just go ahead.
For it.
No, steal my thunder.
I do not want to steal your. You go ahead.
You want to read it together?
You read the first sentence. I'll read the second.
Well, read responsibly on page 6. Go.
Yes.
If a parent gives he likened it to this. if a parent gives a babysitter a credit card and says, make sure the kids have fun while we're out, the parent might expect that the babysitter would take the kids out for ice cream, but would not expect the babysitter to take the kids on an overnight trip to Las Vegas. Likewise, here, without clear congressional permission, the final rule, the FTC's equivalent of a trip to Las Vegas, is unauthorized.
Well, Russell, you left out the most important part about the court in Ryan. The Judge Ada Brown is a Emory Law School alum, so of course she got it right.
Well, we'll see what the Fifth Circuit says.
That's right.
So, all right, so we're going to see what happens with the FTC at this point, and why don't we turn to some of the other developments?
Well, I'm happy to take the lead there and briefly talk about extraterritoriality and a noteworthy decision out of the Seventh Circuit in the Motorola versus Hytera case. All three of us were actively involved in the efforts to support the Defend Trade Secrets Act. And as many of you that are listening may recall, one of the guiding forces behind the enactment of the DTSA was the concern over international misappropriation, the inability of American companies to protect their information, their trade secrets overseas. And China received special focus, and there were a number of anecdotes that were shared in the legislation leading up to the DTSA, the bills and the discussions and the negotiations, talking about some infamous examples. So that was clearly an intention of the DTSA. It was an amendment to the existing Economic Espionage Act, which had language under 18 U.S.C. Section 1837(2) that applied the chapter to conduct occurring outside the United States if an act is in furtherance of the offense that was committed in the U.S. There have been a number of district courts that have applied the extraterritorial application of the DTSA that have found different examples of conduct that occurred in the United States that was in furtherance of what was otherwise overseas misappropriation. And the Motorola case was the first Federal Circuit opinion giving life and reinforcing the importance of that provision. We'll probably talk a little bit more about the Motorola case because it's an unjust enrichment case, and it's one of the few very substantial jury verdicts that seems to have survived as of late. But almost all of the conduct took place in Malaysia. Motorola's technology, its trade secrets relating to digital mobile radios were pretty brazenly stolen by a Chinese competitor from the Malaysian office. There's a note in the Seventh Circuit opinion talking about how outrageous the conduct was and how it was never really disputed by Hytera during the course of the proceedings. Hytera, one of the procedural arguments that they offered was that the DTSA should not be applied to overseas sales, and they were substantial numbers in this case. And they argued that the conduct exclusively took place overseas, and therefore there was nothing in furtherance of the misappropriation that occurred in Malaysia. Motorola countered to the fact that Hytera had sold the digital mobile radios or promoted them or marketed them at trade shows throughout the United States. And I think some of the sales were here in the US too, a product that incorporated the misappropriated features. And the Seventh Circuit rather emphatically confirmed that the DTSA could apply to extraterritorial conduct overseas, worldwide sales, provided you can demonstrate an act in furtherance of the offense that was committed in the United States. And again, here it was just simply the marketing and promotion of the offending product, the product that incorporated the misappropriated technology at U.S. trade shows. So I think it's an important ruling because it reaffirms the reach of the DTSA. From my vantage point, one of the most important IP statutes that exists. And it differentiates the ability of a trade secret owner to recover for losses overseas if they can establish that jurisdictional hook, if you will, of conduct that took place in the United States. So I think that's a significant ruling and an important development that took place in 2024.
Yeah, and John, I'll follow that up. I think another significant series of developments in 2024 was how the courts continued to address and grapple with damages issues in trade secret cases. As you alluded to, there have been quite a few large jury verdicts in trade secret cases, but in many of them, they've been set aside for a variety of reasons, but many of them based on problems with the plaintiff's damages calculation or the damages model. And a couple of examples, the biggest one being the Appian case in Virginia, where there was the jury awarded more than $2 billion in unjust enrichment damages against Pegasus for trade secret misappropriation. And in essence, after showing the misappropriation, the trial court in Virginia allowed Appian to prove only the sales that Pegasystems had made, but shifted the burden to Pegasystems to show those that were not attributable to the misappropriation. And so Pegasystems, and in fact, the AIPLA weighed in on this through an amicus brief, argued that by not requiring the plaintiff Appian to prove a causal connection between the sale and the misappropriation before shifting the burden to the defendants, the court erred. And in July, the Virginia Court of Appeals agreed and reversed the jury award, basically finding that the unjust enrichment instruction that the court had given let the plaintiff prove only the defendant's total sales and relieve the plaintiff of its burden to prove proximate cause for the misappropriation. And I think that's something that is a trend that we're seeing, where the courts are saying you can't just sort of put up this evidence of what all the sales are without actually showing what sales were attributable to the misappropriation. Or, and I'll let John talk a little bit about this because I've got a case that's now on appeal to the Ninth Circuit where a very similar issue arose, where the plaintiff alleged to have 9 trade secrets. The judge had required them to identify their trade secrets with specificity, and they went to trial on 9. The judge threw 2 out on judgment as a matter of law. And then the jury found in their favor on only 1 of them. But their damages expert had admitted that his damages model was based on the bundle, all of the trade secrets, and that he had not provided the jury with any basis on which to calculate damages if they didn't find in the plaintiff's favor on all of them. And so by failing to apportion either among the trade secrets or between the alleged misappropriation of trade secrets and sales of the product that had nothing to do with the alleged misappropriation, the plaintiff's damages model failed. And I think that's something that, we're seeing quite a bit of. There's the Versada case out of Michigan that's on appeal now on that same issue.
Yeah, it amazes me that people take that all or nothing approach with their trade secrets. And I understand there are members of the plaintiff's bar community that are aggressive and feel they have a good case, so they want to force the jury into the corner and have them go big or go home. But I've never understood that approach. And as you mentioned, the Versada case out of Detroit, the case brought against Ford, had the very same issue. The plaintiffs made the election to provide a total sum of damages, but didn't break it down by trade secrets. And when the jury didn't elected to find that some of the trade secrets were misappropriated, or others either weren't trade secrets or weren't misappropriated, the plaintiff had the damages thrown out in that case as well. To me, Ben, what's really interesting is we've talked at length about how trade secret cases are evolving and becoming more and more like patent cases. And you see these disputes, which are largely brought against customers or vendors or large companies as opposed to individuals, because they're not judgment proof like employees, and there's an opportunity for a potential sizable award if there is a compelling case of misappropriation. So these issues are probably been worked out long ago by the patent bar or in other more developed IP regimes, and we're still kind of figuring things out on the trade secret side, it seems.
Yeah, and I do think this idea of apportionment is borrowed from, in some regards, from patent law.
Yep.
And
Yep.
Has its origins there. But I think that the same principle applies and certainly makes sense. And I think that the courts, at least in my view, seem to be doing a good job of making sure that trade secret plaintiffs are, they're not getting a windfall, that they're actually proving what either their damages, what damages they've suffered, or if they're proceeding under unjust enrichment and how the defendant was allegedly unjustly enriched or purportedly unjustly enriched, that, they're holding their feet to the fire to make sure that that's not just some windfall to the plaintiff, that it is based in causation and proximate cause and in reality as to what the actual benefit to the defendant has been as a result of the alleged misappropriation.
Yeah, you've touched on that, and I want to make sure that we leave time for some of the other developments of the year and an opportunity to talk about what we may see coming up in 2025. But you raise a good point with unjust enrichment. For example, the Second Circuit's hesitancy to award avoided costs in the Sintel case and under an unjust enrichment theory versus the comfort, for lack of a better word, that the Seventh Circuit has had in the Tata case and in Motorola in awarding avoided cost damages or not having any hesitancy to do so in connection with the unjust enrichment theories that are presented for them. So a lot that needs to be worked out, but a really interesting ongoing development in trade secret law.
Right, terrific. Any other DTSA decisions that we need to cover today? Otherwise, we can move on to the state side of things.
Yeah, why don't we move on to the state side of things so we use our time effectively?
Yeah, and just real quick though, if people are interested in others, there's two really good resources. Our good friend Jim Cooley has a great blog, and he did a really nice summary of some of the key decisions from this year that came out on December 27th. And then our friend Lauren Linderman at Fager, Drinkler, and Biddle, she and some of her partners had a little recap in Law 360 that was good. So if you're looking for additional information on trade secret developments in 2024, those are two good resources.
Actually, I'm going to give one more resource for people, which is not related to the DTSA piece, but actually is related to one of the state law issues, the California issue. Let me give background, and then I'm going to tell you what the place to look is. So the background is that at the end of 2023, California passed modifications to its state statute that bans non-competes and other restrictive covenants. Those went into effect on January 1 of this year and basically created a lot of confusion about whether the ban would operate to basically invalidate every non-compete around the country if somebody either had any connection to California. So either the employee worked there, the employee lived there, the employee moved there, the California employer was based there, but the employee may have been out of state. All of those questions were before the court at various points during this year, or at least on their way to the courts. And Jonathan Crook at Fisher Phillips did a very nice blog post covering 3 of the cases. I think there are about 7 at this point that I've seen, but he covered 3 of the cases, and it's worth taking a look at his blog post. It came out just yesterday, I believe. Yeah, just yesterday. So take a look at that too, because that's a really good resource. He's very good at keeping up with the key cases, and so be on the lookout for that.
Hey, Russell, I do want to mention on that. I know Jonathan. I know him really well. He's a good guy. I really like his blue pencil box. The one thing I will mention that I don't know that you're aware of is that since he sold the publication essentially to Fisher and Phillips and joined the firm, there are certain cases they won't report on if their firm, either represented one of the parties or represents the client. Unless the client gives them permission. So while it's a great resource, it's not always comprehensive for that reason. And I just think it's important for people to know that, because you're not going to get every case. We had a very key decision out of the Maryland District Court that did not get published, and turned out it was for that reason. So
Interesting.
just something to keep in mind.
Is that a noteworthy case of 2024 or something else?
I think it is noteworthy, but it'll be more noteworthy when the Fourth Circuit affirms, which I'm hoping will be sometime in 2025, because we just argued it back in December. But the key issue there that I think is fascinating is, can you return an email? So if you have an agreement that says after you leave employment, you got to return all information, et cetera. And someone has an email they forwarded to themselves and they delete it, but don't return it. Can it actually be returned? Because our argument and the Fourth Circuit judges on the panel seem to agree, which is if you forward it back, you're just creating another copy. There's really no way to, as a practical matter, return an email. You can either delete it or you can make a copy and send it back, but that has not actually been returned. You still have the email if you do that. So we will see what the Fourth Circuit says about that sometime in the next few months.
That's really interesting. I look forward to that. We can cover that on another podcast episode.
Absolutely. But real quick, while we're on resources, Jim Pooley's blog mentions there's this trade secret case management judicial guide also
Yeah.
that when we tried our case out in California, we found it immensely helpful. It's a guide that was created by the Federal Judicial Center, and it's been distributed to all the federal courts. So if you want to have some insight into what federal judges are looking at as they're managing your trade secrets case, it's a great resource.
Yeah, it actually is worth noting that in addition to Jim Pooley, who was involved in the drafting of that, the other people that you would think of, Vicky Cundiff, David Ameling, Elizabeth Rowe was on there, as well as Peter Torin, Rebecca Wexler, and Peter Manel. So
It's an all-star lineup.
It really is. It really is. It is a tremendous resource. There's an awful lot of work that went into that, and it's a great place to start if you've got a case that's going to trial.
Agreed. So, all right, so let's turn then to the state legislative developments first, and I'll run through those, and then we can turn to just a couple of noteworthy state court decisions. So, starting on the legislative side, this past year in 2024, 73 bills that were pending, 10 of them did propose a total ban of non-competes. 15 proposed notice requirements. 29 of them were in the healthcare space. These are, by the way, not mutually exclusive. Something may have required a notice and may also have applied in the healthcare space. So 10 bans, 15 notices, 29 in the healthcare space, 15 would have required penalties. Overall, out of the 73 bills, 10 of them passed. Colorado passed one of those. They limited the remedies that were available in certain contexts involving a non-compete that should not have been used. Illinois passed two bills. One was a bill dealing with non-competes in the healthcare space insofar as it concerns veterans. I think it was mental health for veterans. Then the second bill dealt with a clarification of the construction worker exemption under their prior amendment to their statute. Iowa removed penalties in certain instances in the context of healthcare employment agencies. Louisiana had a healthcare bill. Maryland had a healthcare bill, and it also applied to veterinarians and vet techs. Pennsylvania had a healthcare bill. These are all bills that passed. Rhode Island had two bills that passed and basically made one law, and that was regarding restrictions on the use of non-competes for advanced practice nurses. And Washington State had a law that expanded their prior overhaul of their non-compete law and applied the non-compete law to certain non-solicitation agreements, specifically non-solicitation agreements that involved prospective customers. So if you have a non-solicit in Washington and it applies to non-service agreements or non-solicitation agreements for prospective customers, it now will be treated as a non-compete under the statute. There were some other bills. Colorado had a bill that didn't pass, that did pass, that restricts the use of what they call TRAPs, the training repayment agreements, which you would think is just TRAs, but they call it training repayment agreement provisions. So they could call it TRAPs pejoratively. That's not just Colorado, that's the ether. Minnesota has a disintermediation law now, and basically You can't eliminate the middleman in agreements where somebody's providing staffing services. And Washington also made it harder to enforce non-competes overall. So those are the other laws that passed this year. Instructively, among the things that didn't pass were in Rhode Island and Maine, there were bills that made it all the way to the governor to ban non-compete. So out of those 10 non-compete bills that would have banned non-competes, two of them made it to governors, one in Rhode Island, one in Maine, and both governors vetoed. And as you may remember, the prior year, New York vetoed, the Governor Hochul in New York vetoed a similar non-compete ban that made it to her desk, and Minnesota, in contrast, adopted it. So as of July of 2023, Minnesota became the fourth state to currently ban non-competes. For 2025, just quickly, I mean, I won't predict yet, at least in what we're going to see, but there have already been a handful of bills that have been pre-filed. So you can expect that there will be some more activity. Let's leave the non-compete statute side of things and turn to non-compete case law. And the one case that I really wanted to make sure we covered was the Delaware Supreme Court in LKQ Corporation versus Rutledge. And basically, that court involved a forfeiture for competition provision. Those are agreements that say when you leave here, you can go work for a competitor. It's not a ban. You're not prohibited from working for the competitor, but if you do, you forfeit something, usually something of very significant value that you would have otherwise received. And so earlier in 2024, so back, I think it was in January of 2024, the Delaware Supreme Court issued a case called Cantor Fitzgerald versus Ainsley. And in that case, the court said forfeiture for competition agreements that arise in the context of a partnership agreement are regular contracts. They're not subject to the same rules as non-competes. The court bought into the employee choice doctrine. Basically, the employee had the ability to make this decision. They made the choice, and they're going to suffer the consequences. It is a contract like any other contract. They have their contractual defenses. Fast forward, and the Seventh Circuit certified a question to the Delaware Supreme Court, specifically whether Cantor Fitzgerald, that case that the Delaware Supreme Court decided earlier, precludes reviewing forfeiture for competition provisions for reasonableness in circumstances outside of the limited partnership context. And if Cantor Fitzgerald did not preclude that type of review, well, what are the factors? The Delaware Supreme Court made it easy. They said Cantor Fitzgerald does apply in all contexts. And so an employment agreement that contains a forfeiture for competition provision will be treated like a regular standard contract term, not subject to any sort of reasonableness analysis. So that's where we are. That is a huge development in Delaware because there had been a string of cases in Delaware that's really been saying, essentially, don't come here to enforce your non-competes. And if you do come here and try to enforce them, we are going to be applying a very, very, very strict standard. And it looked like that was going to apply even to forfeiture for competition provisions. It does not. So we'll see where those cases go. Those were all in the Delaware Chancery Court prior to the Delaware Supreme Court taking on the Cantor Fitzgerald case and then certifying this question in LKQ. So we'll see how things progress in Delaware now and whether the Delaware Supreme Court has signaled, hey, we are more friendly to these agreements, or no, we're just going to treat forfeiture for competition agreements very differently. So we'll see. There was also a case in Georgia, in the Georgia Supreme Court, and since we have our resident Georgia expert, Ben, why don't you cover that one?
Yeah, thanks, Russell. Yeah, so it was an interesting case that had to do with a non-recruitment covenant. And so just by way of background, for those who don't know, in 2011, the legislature here passed a statute that sort of was a reaction to a lot of the common law. The courts had been striking down non-competes and other restrictive covenants with some regularity. And the idea was the statute was intended to make non-competes and other restrictive covenants more enforceable. But as you would expect, the statute says that such restrictions to be enforceable have to be reasonable in terms of time, geographic area, and scope of prohibited activities. And in the definition of restrictive covenant, it was broad enough to cover non-recruitment covenants. So even under the old hostile common law, the courts had enforced non-recruitment covenants that did not contain a territorial limitation. But the argument was, well, now the statute says to be enforceable, a covenant has to be reasonable in time, geographic area, and scope of prohibited activities. So the Georgia Statewide Business Court, which was a relatively new court at the time, Judge Davis found a non-recruitment covenant to be unenforceable that did not contain a geographic territory, particularly because it applied to all employees of the company. And it was a fairly large company with national operations. But the essence of his ruling was without a territory, it was not enforceable. The Georgia Court of Appeals affirmed, and the employer sought cert to the Georgia Supreme Court. Supreme Court granted cert and held that, yes, a non-recruitment covenant must comply with the requirement in the statute that it be reasonable in terms of time, geographic area, and scope. However, basically the Supreme Court said, but you don't need to have a territory because the statute does not mandate an explicit geographic term, and that to be reasonable, the geographic area can be expressly stated or implied, and that by applying only to the company's employees, the non-recruitment covenant implicitly had a sufficient geographic restriction. So it's an interesting development, and I think the open question, there's actually a footnote that talks about, there was a prior Court of Appeals case that dealt with this in the customer context. The statute says you can have a non-solicit of customers that does not contain a territory if it's limited to customers with whom the employee had material contact. Material contact is defined in the statute. It's actually pretty broad. But there was some question, well, could you have a no service or a no acceptance covenant without a territory? And the Carpet Care case, a Court of Appeals case, said, no, you cannot, that you have to have a territory in order for a no acceptance or no service provision to be enforceable. And I think the open question is that under Wimmer, if a geographic restriction can be implied in the context of an employee non-recruitment covenant, can it also be implied in the context of a customer no acceptance or no service provision? And so that's an issue that we're going to be looking out for in 2025. I don't know if there's a case out there percolating where that issue may come up to the Supreme Court, but I think that's one that the Wimmer decision suggests that the court may be headed in that direction, and that for a no service or no accept provision, you would not need a territory either. But it was a fairly significant development here, but I think it also has implications nationally in terms of, what is reasonable when it comes to a employee non-recruitment covenant.
Well, it certainly has implications nationally because as national companies or even regional companies are working on their covenants, they need to make sure that they're complying with the laws of the various states where their employees are located, just in case they wind up having litigation in those states with those employees, which does often happen. So you can try as you might to avoid a particular state's law, but you may not be successful. So you should always be aware of what the state laws are around the country so that your agreements are in compliance with them, or at least you're making a calculated decision to avoid compliance. So this made it very easy to comply with the Georgia statute, similarly to the way you would comply with it in most other states. Like this, the same law in most other states.
Agreed.
So with that in mind, why don't we turn to predictions in our last few minutes here? Ben, you want to kick that off for us?
Yeah, I think, you're more the expert on this, but I do think we'll continue to see state legislatures looking at legislation around non-competes and other restrictive covenants, and likely to see, as you were pointing out, with all the bills that are pending, some more in that area, and probably continuing to rein in the use of, sometimes the abuse of non-competes and other restrictive covenants. I do think, as I mentioned, when I mentioned this damages issue, I think we're going to continue to see cases in the trade secrets context addressing the parameters and the requirements for proving damages in trade secrets cases to come to a clearer picture of, when is it that a plaintiff has really proven recoverable damages and when has a plaintiff, gone too far and basically gotten a windfall. So to me, those are going to be some of the key issues that I would expect to see in 2025.
John, how about you?
I would agree with Ben on both those points. Those were the two main things that I felt were going to be areas of greater activity. I'd supplement them this way. I think that not only are you going to see more legislation, but Ben, you brought to our attention the activity that's been going on with a number of state attorney generals or state administrators who are following the FTC's lead. I think your firm did a really fine blog post about the problems Valvoline had when it had low-wage employees sign non-competes and a number of states banded together, Minnesota, New York, Massachusetts, Maryland. I can't remember, there may have been one or two others, but they collectively pursued a strategy similar to what the FTC's been doing to some extent with its individual prosecutions, if you will. So I think you'll see more of that type of activity, particularly if the FTC cedes that area to the states. So that's one possibility. I think you'll see diminished federal action. We've seen activity with the NLRB, for example. We didn't get a chance to really cover that, but the Cincinnati regional office has been very aggressive in policing the use of non-competes to the extent they've been used to chill the ability of employees to organize or exercise their rights as employees. And I think increasingly we'll see under the new administration some backing off or standing down, if you will, of those things. But I do think finally you're going to see greater judicial skepticism with non-competes. We're seeing it in Ohio, and I didn't want to lengthen our discussion about developments of the past year, but in Cincinnati, one of the leading appellate courts here in the state of Ohio issued a relatively remarkable decision where it departed from pretty settled Ohio Supreme Court authority requiring the reformation of an otherwise unreasonable non-compete. And that court held that a trial court did not have to reform an unreasonable non-compete and could essentially toss the non-compete or elect not to enforce it at all. So I think that's a noteworthy development. There is just, I think the headwinds that have led to the FTC's activity and the legislative activity that Russell has so thoroughly described are going to continue into 2025.
I agree with everything that you guys have been saying. I'm going to have a few comments around the edges. First of all, what I should have mentioned in the discussion about the developments in 2024 was a very important Third Circuit decision. It was in the Delaware State Sportsmen's Association versus the Delaware Department of Homeland Security. Now, it was not in the context of trade secret cases or restrictive covenant cases. It was in a much different area of law. But the court basically said, hey, district courts, you're issuing too many preliminary injunctions. Stop it. The standard is higher. Irreparable harm really means irreparable harm. Now, when you apply that in the context of trade secrets and restrictive covenants, you could see that maybe the standard has been applied appropriately in the Third Circuit by the district courts, but that's something that remains to be seen. So I think we're going to see that get fleshed out a bit in 2025. I agree on the legislative front. I think we're going to see a lot more of that. We've already seen a couple of pre-filed bills, but I think we're going to see a bunch. One of the things you hear is that with the FTC's rule probably going away, I think we are all almost certain that will be gone by the end of the year. But regardless, the FTC's rule is certainly not effective at this point, and people think that the impact of the FTC's efforts have been to draw media attention to the need to ban non-competes. And my take is a little bit different from that. I do think that the FTC's efforts have drawn attention of the media and therefore attention to these issues. But I think that the legislatures were already all over these things. There were so many bills pending this past year and in the years before. It all started after Jimmy Johnson 2014 when they used non-competes for their sandwich workers, and that all wound up resulting in a firestorm of media attention and all sorts of efforts at the federal level and the state levels. So I do think that that was the genesis of all of this real push on the legislative front. I do think it will continue. I don't think the FTC's impact is to push it along further. I think the FTC's impact would have been to stop it in its tracks. So I think that'll continue. I also think that companies will continue using non-competes. I think that companies will probably be very careful in their review of their agreements, more so than they had been in the past. I think in the past, if you had language that said thou shalt not compete, years ago that was okay. As time has moved on, that has become less and less viable, and I think even more so now. And I think companies will be focused on making sure the language in their agreements is narrow. I think they will also include other agreements, either in place of non-competes or as backups to non-competes, things like forfeiture for competition provisions. They can live side by side, and a lot of companies are already doing that. I think we'll see more companies doing that. I think we'll see other companies doing springing non-competes. I think, John, I love the name that you gave it. You called it a timeout non-compete. The concept is that you don't have a non-compete, but if you violate one of your other restrictive covenants, the remedy for that the court will impose is a non-compete. And you write that out in the contract, the court enforces it as the remedy from an injunctive standpoint. So I think we'll see that. And I also think we're going to see more agreements then, more companies focusing on these alternative agreements, not necessarily in the alternative, but certainly using them in conjunction with the other types of agreements that they have. I do agree with John that the courts are going to be more skeptical moving forward, although maybe not so much in Delaware. We'll see with the Delaware Supreme Court's decision, maybe things turn a little bit. And I also think that maybe, the federal courts may be in a different place from where the state courts are.
But yeah, here a lot of it depends on which judge you get in the federal courts. Tends to be a divide.
So I think, we're making predictions in the abstract, but when you actually start to dig down and you look at the particular judges, the particular courts, in the particular states, I think it will vary. So time will tell, but we'll certainly be discussing them in podcast episodes moving forward. So thank you to our audience.
Happy New Year to both of you and to our listeners.
Absolutely.
Happy New Year.
That concludes today's show. You can visit the official podcast website at fairlycompeting.com. And please note that this show is provided for informational purposes only. None of your hosts is providing legal advice, and your use of this podcast does not create an attorney-client relationship in any respect. Thank you all for joining us.